Please welcome Jonathan Handel.
Thank you. Well, thank you very much, Michael. And of course, I'm going to do almost nothing of the sort, just to set expectations. This is actually a very complicated bill. It sounds a revision to the law now. It sounds simple, the ABC test, but in fact, it's quite complicated. Let me ask, as it gets darker and darker, a couple of questions of the audience, so I get a sense of some of the ways the law will affect you.
Maybe the lights a little bit up. We're not showing video.
Yeah, that's good. That's good. Thank you. How many folks here primarily earn their living as an employee? You primarily get a W-2. Okay, small number of people. How many people primarily earn their living as an independent contractor, get 1099s? How many people roughly or substantially both? A few people. And how many folks have their own corporation, whether a C Corp or an LLC that you operate through? Okay, great. So those are three different models of what's similar in all of them. What's the common thread is you're providing services to somebody, and you're ultimately getting paid for that. But the law is very, I was going to say bipolar, I guess very binary or really tertiary if you counting the corporate entity approach, and there are a lot of different aspects to those different models. But let's start first of all. What is AB5? It's a new law, so it's referred to. AB5 was Assembly Bill 5, but now that it's passed, it's actually part of the Labor Code, and which is the statute books, one of the statute books in California. It's also part of various other sections of the law. Mostly effective January 1st of this year. In very broad strokes, it classifies most workers as employees, not as independent contractors. Now, that's a very broad stroke, and we'll get into detail. What it does is it takes a California Supreme Court case called Dynamex, which sounds like, I don't know, it sounds like a good title for a closed-end series, for a limited series. That was a case that was decided in 2018, and the statute basically bakes Dynamex into the law, into the statute books. So laws are made both by courts and by the legislature, and by referendum, for that matter, in this state. And here, the legislature is taking the Dynamex decision and saying, we like it. It implements the ABC test for classification. Now, that sounds nice and simple, but in fact, it's not so simple. There are many, many exceptions, and we will see in a few minutes a flow chart that proves to you that I was indeed an applied math and computer science major as an undergrad, and that I think this audience in particular will appreciate because of it. In addition, you should know that there are lawsuits that are challenging the law or aspects of it. Freelance journalists have filed Association of Freelance Journalists has filed a lawsuit, or two associations actually. The trucking industry has a preliminary injunction as to the aspect that affects them. And Uber and Lyft, who are a main target of this bill, and ironically, it's not even clear to me that the law effectively does reclassify Uber and Lyft drivers as employees. They are spending reportedly $100 million on a ballot initiative to undo the law, or at least the portion that affects them. Another thing that's kind of interesting to me was that the law focuses on things like wage and hour laws, laws about overtime and so forth, unemployment insurance, and certain other aspects. It doesn't actually explicitly mention taxes. I alluded to W-2s and 1099s. Taxes are not explicitly referenced here. I'll have to check the statutes and see if the tax code cross-references into the modifications of the labor code that we're going to look at. But in any event, if somebody feels that you are an employee or are an independent contractor for purposes under the tests that we're going to look at, they're likely to treat you that way for tax purposes. And that would be for federal tax purposes as well as state. Even though this is a state law, the likelihood that someone is going to start treating you as a state employee but a federal independent contractor is pretty less than nil. So what we're talking about here effectively is classification for a wide variety of purposes. Now again, three models: employee, independent contractor, and company, which can include loan-out corporations. If you're a well-compensated actor, writer, or director in particular, you often set up a corporation that's slightly different in its structure than the corporation that you may have set up for yourself as an operating company, as an editor. I'll note that in Canada, there's a concept called dependent contractors that tries to split the difference between these different categories. But U.S. law is still an artifact of an industrial age where there are very distinct differences between these different categories. And let's look in particular at employees, pro and con. What's good about being classified as an employee? What's not so good? First of all, typically, there's more stability and permanence. Now, most people don't have employment contracts, like the way executives or highly paid computer programmers at Google might. They might get a 3-year contract and they can't get fired except for cause. Most people are at-will employees. So to some extent, you might say, well, it's illusory. They can fire you at any moment at a company. But the reality still is that an employment relationship typically lasts, at least outside of this industry. Now, we'll get into the way things work here in a couple of minutes. But, in the traditional economy, if you work for, an insurance company or whatever, your job is probably going to continue for a while. I should ask, by the way, how many people are members of a union? So again, a smattering. We'll get to the relevance of that. So what else about employees? A variety of protections under the law. Wage and hour laws. Those are the laws that say that people earning under a certain amount of money have to have a lunch break and 2 rest breaks during the day and have to be paid overtime after a certain number of hours during the day and during the week. Unemployment insurance, workers' comp. Those are all associated with the employment relationship, not with an independent contractor relationship. Anti-discrimination laws. There may be some applicability, at least in California, of anti-discrimination laws to an independent contractor relationship. I'm not 100% sure. But in general, what's clear is that you can't say, well, I'm not going to hire you because you're black or you're gay or you're a woman or whatever, or you're a man or you're straight or what have you. Whereas, can you say, I'm not going to hire that independent contractor because I don't like, women-owned businesses, I want to stick with guys? Less clear to me, but certainly less solidly the case. There's limited liability also. If you're an employee of a company and you work on a project and the client gets angry, they'll typically sue the company. They won't sue you if it comes down to a lawsuit. So you've got protection, within the structure of the company. Now, I mentioned the structure of a company or the outline of a company. Part of what's driving this and driving Dynamex and AB5 is dramatic changes in what business school people refer to as the boundaries of the firm. In other words, who's part of a company, who's not. Outsourcing, where certain functions in a company, people get fired and then rehired to an external company providing services, like an office services company. Offshoring, where jobs are sent, altogether offshore. And technology platforms, sharing platforms like Uber and Lyft that disintermediate the concept of looking for a ride from the concept of providing a ride. All of those things combined with independent contractors, growth of self-employment, are changing the economy, although not as quickly in the larger economy as one might think. The entertainment world is a bit ahead of the curve. ever since the collapse of the studio system in the late 40s, this has been, especially on the motion picture side and on, in some of the below the line aspects, has been very much a gig economy. The outside general economy is still, notwithstanding the fact that there's a lot of news articles and it's very interesting to read about Uber and Lyft and, gig work and so forth. The outside economy is still predominantly an employment economy, but it's shifting. What else is good about being an employee? You get benefits if at least if the employer is reasonably enlightened and you're reasonably well paid. So health insurance, employer 401k matching, various other benefits. The employer pays half of the Social Security and Medicare tax. That tax is about 15.5%. The employer pays half of that, and you get half of that deducted from your paycheck. And employees can unionize. Independent contractors cannot. Now, this industry is a little weird in that if you look at the way a feature film writer, as opposed to a TV writer, works, they go off and they get an assignment. Say they get to write the next Superman movie or whatever. They go off, they go home, they use their own Mac, they set their own hours, and it feels very much like an independent contractor. But in fact, they're paid as an employee, and the unionization is recognized. The work is, covered by the Writers Guild if the company is signatory to the Writers Guild agreement. What's not so good about being an employee? You can't deduct business expenses, and in particular, a large form of business expenses for, how many people here have an agent, a manager, or other representative on percentage? So a small number of people, but a few. And prior to the Trump tax reforms or tax revisions, you could deduct those, even as an employee, you could deduct those as business expenses. And under limited circumstances as an employee, you could deduct home office and automobile expenses. That's all gone. You can't deduct, as an employee, you cannot deduct agent, manager, lawyer commissions, home office, automobile, other unreimbursed business expenses. What else is not so good about being an employee? You're typically tied to a single employer, at least in traditional businesses. Again, not so much in our business, where people will work for a lot of employers in the course of a year. But, if you're somebody who likes stability and likes working at the same place all the time in the traditional economy, that's good. If you'd like, on the other hand, if you want to be part of you feel you want to be part of a more dynamic marketplace of providing services, that might not be so good. You have less autonomy. Your employer tells you show up at 8:30, 9 a.m. Here's your cubicle. Here's where you're going to work. Stay till you get your work done, at least approximately 6 o'clock, 7 o'clock, whatever it might be. And here's what I want you to work on now. For people who have a high need for autonomy, the employment relationship is not ideal. And finally, copyright. For those of us who are creating copyrightable property, whether it's edited footage, whether it's directing footage, whether it's writing a screenplay, in an employment relationship, work for hire is the default. The employer owns the copyright. In an independent contractor relationship, work for hire can be set up through contract under many circumstances, but not all. And otherwise, the copyright is usually assigned. So there's subtle differences in the way copyright works. So independent contractor or corporate service provider relationship, as I've been alluding to, it's the converse of most of the employee status items that I just went through. And one other thing, if you're well compensated, if you're doing reasonably well for yourself, there are some extremely aggressive retirement plan options available for independent contractors. Solo 401ks, HSAs under some circumstances, defined benefit plans, things that allow you to shield 35% or more of your income from taxes, a much higher percentage than employees are able to shield using IRAs and employer-related vehicles. Now, let's get to AB5. I promised you a flow chart. Now, let me ask, first of all, I have another version of this that I can zoom in on. How many people, are people able to read the text here at all? No, I didn't think so. So let me explain in broad outline what this chart is showing, and then we will take a look. By the way, how's my timing?
You have 15 minutes.
15 minutes. Okay, great.
We're maybe give or take a 5.
Give-
Paul's going to be here later, so yeah.
Oh, fine, fine. And we'll have time for questions. So let me explain in broad strokes what this chart is showing you, and then we'll go to a JPEG version where I'll zoom in, piece by piece. The default rule, which is that orange gradient circle on the left there, is now the ABC test, which is described in the green rectangle. And if you pass the ABC test, then you're an independent contractor. If you quote unquote fail the test, you're an employee. The blue diamonds then deal with exceptions to the ABC test. Certain occupations are exempted. Certain other so-called professional services agreements are exempted. A grab bag of other things like, believe it or not, a Repo Man. How many people saw the movie Repo Man?
I worked on it.
You worked on it. Fantastic. Fantastic. Well, it is a great movie, and it's a great exemption from AB5 now. So it's it lives on. Repo Men, motor clubs. I think that's like the AAA. A lot of these exceptions, doctors, lawyers, a lot of these exceptions are not going to be relevant to this audience, but certain of them are. And so what we're going to do is look at AB5 and then look at the exceptions that are relevant and explain the test called the Borello test, which is that big green box that applies when AB5, or when the ABC test rather does not apply. So that said, let me pull up the other graphic. And while I'm doing that, I'll just mention that there's a completely separate issue that comes up in this business, which is interns, unpaid interns and volunteers. And that's not a topic that we're going to deal with today. AB5 does not alter the test for when someone is legitimately considered an unpaid intern or volunteer versus when they are considered a worker of one category or another. The ABC test. This is the test from Dynamex that's now in the law, and that applies unless an exception applies. In order to be an independent contractor, you have to meet all three of these prongs, A, B, and C. Now, what are these three separate criteria? A, the worker has to be free from company control and direction. And that has to be reflected both in the contract between the worker and the hiring company, and has to be actually true in fact. So just because the contract says that you exercise your own discretion and you're not controlled or micromanaged by the company, that has to be true, actually true in terms of the facts on the ground. Now,
That seems pretty vague and broad.
it is vague and broad, and it's a very difficult. This particular criterion was key under the older test called Burello from 1989. That's the one that applies when these exceptions apply, if the ABC test doesn't apply. So this issue of control and direction is very key. The trouble with that as a criterion is that the more skilled the profession, the less detailed control and direction you would expect to get under any circumstances, whether from an employer or from an outside client, an independent contractor type arrangement. So, if you're an editor, which most of you are, you know better than I the sort of directions that you get from the director and the producer, or whoever it is that's, say it's an advertisement, the agency, whoever's controlling the engagement. You're usually not going to get told, in general, gee, we only want this kind of transition, and we want, 5-frame, lead in for the sound before the picture cuts, and like, no, we want, you'll get a direction. We want energy. We want energy and excitement in this piece. Or we want energy and excitement here, and then go to, take it calmer, take it a little slower, and then bring it back up, okay, as the drama increases. I mean, I assume that those are the sorts of directions that you get. As a lawyer, the sort of directions I get from someone are not, micromanaged. So this is a very hard prong to really get a handle around. The second one, B, the work that you're doing for the company has to be outside the usual course of the company's business. So what does that mean? If there is a company that provides editing services for motion pictures, and you're an editor, and the company hires you as a freelance, engages you as a freelance editor, an independent contractor, to do some editing because they need overflow, or they like your particular talent and style for this particular project or whatever. Guess what? You failed that prong. You cannot be engaged as an independent contractor. Okay? So what does that mean outside the usual course of the company's business? The editing company wants to have a website, so they engage a web designer. Well, the editing company's not in the business of creating websites. The work that the web designer is doing is outside the course and scope of the company's usual business. The company has a kitchen, and the sink gets clogged up, so they bring in a plumber. They're not a plumbing company, they're an editing company. So that's outside the course and scope. But if you're doing the same type of work that is the core of the company's business, then you failed that prong, and you are an employee under the new test, unless one of these exceptions applies, which we'll get to. And finally, the worker has to be customarily engaged in an independent trade, occupation, or business of the same nature as the work that you're doing for the company. So if you have to hold yourself out to the general public, or B2B, general potential clientele, as a freelance editor. If you don't, if you're just working for this one company, the relationship is not going to be recognized as an independent contractor relationship. Now, going back for a minute, I mean, what's behind all this? People that are not well paid have been significantly abused with great frequency by being misclassified as independent contractors and then not paid overtime, not allowed meal breaks, things of that sort. There is a baby and bathwater issue here, which is that people that are paid better and might want to be viewed as independent contractors are getting swept in by AB5 and may no longer have that option. Now, let's look at the exemptions. Exempted occupations. Turns out that none of these are ones that I think anyone here, with the possible except, are there any architects here? No. Okay. I assume there are no podiatrists, no lawyers, engineers. It doesn't really mean software. I doubt it means software engineer, FYI. Private investigator or accountant, various other people, commercial fishermen. Those folks will use the Borello test, which we'll get to in a minute, because we're going to look at another category of exemption. Professional services contract. So the way this exemption works is you've got to fall into one of these buckets of certain occupations, and there are some other criteria about having an independent business, so we'll get to those. So marketing, if it's original and creative. I'll skip over things that wouldn't apply here at all. Graphic design, fine artist, still photographer or photojournalist, but not one who works for the motion picture or television industry. Those are handled by the AB5, by the ABC test. And even those who do work for the news industry, you can only submit up to 35 licensed submissions per company. Freelance writer, editor, or newspaper cartoonist with fewer than 35 submissions per company. Barbers, well, okay, we don't have any barbers here. I could use one. Now, in addition to being in one of those professions, you have to satisfy all of these conditions here. You have to have a business location, which could be a home office, and a business license, and the power to set or negotiate your rates, set your own hours. You're available to other clients, not just for the one company, and you exercise discretion and judgment. Okay, there's a little bit of the vagueness. Discretion and judgment is almost the flip side of, or another way of saying not under the control of the company. And we talked about that, the difficulty in understanding that a moment ago. All right, real estate and repo man, we'll skip over that. Bona fide business-to-business contract. Now, this is important for those of you who operate under, who have a company that you use. You may feel that that by having a company that is the one that actually is the contracting party with whoever you're providing services to, that means you're not an employee. But now it's not quite so clear. What we see here is that there are a lot of conditions, all of which have to be met. And what are these conditions? And incidentally, I'll make this PowerPoint available to people. My email is jh@jhandel.com, or you can just go to jhandel.com, and that's E before L, so JHANDEL. So, once again, the provider has to be free from the company's, so the provider is you providing services, and the company is the company or entity or whoever that's receiving your services. So the provider has to be free from the company's control and direction, again, both in terms of what's stated in the contract and in actual fact. The work has to be provided to the company, not to the company's customers. So the plumber who's, or the graphic designer, let's say the web designer, who's designing a website for the company, for the editing company, that work is being provided for the editing company, not for the editing company's customers. They're not the editing company's customers, the producers and directors are not getting web design services. But when you do editing for a company that provides editing services, those services are being a pass-through. They are actually for the underlying client. So we failed that prong, and that appears to mean, anyways, that even though you have a company that you're using to provide services, that the law may not respect that as an independent contractor relationship, and may insist that you're an employee. Now, this issue of the law respecting things, I should note, if you don't complain and the company doesn't complain, maybe no harm, no foul. But if the taxing authorities or other state authorities, for some reason, start paying attention to the particular relationship, they can reclassify, notwithstanding what you and the company want. Whether that's likely to happen, whether it's, who knows? What are the other conditions? There has to be a written contract. You have to have any necessary licenses or tax registration, business tax registration. You have to have a separate business location, separate from the client. It doesn't explicitly say that can be in a home office, so who knows if a home office suffices here or not. You have to be engaged in this as an independent business, so you're available to other clients, in other words. And you actually have to have other clients without restriction from the company. Now that's interesting. What if you agree with a company that you won't work for their direct competitors, but you can still work for other potential clients, but not for their direct competitors, in return for which they're paying you an especially large premium for your work. That would appear to fail that provision. You have to hold yourself out to the public as available providing services. You have to provide your own tools, vehicles, and equipment. You need the ability to negotiate your own rates, set your own hours and location, and you're not providing licensed contractor work, the building contractor, like the sort of people who work on your house. All right. If all that applies, we go to Borello. Now, construction subcontractors, we're not going to talk about that. Referral agencies, I'll just note briefly, and we won't talk about motor clubs either, but I will note that referral agencies, if any of you are involved with an agency that connects clients to you, refers business to you, certain categories of referral agency are exempt from the ABC test, including those who refer to providers of graphic design services, photography, and a variety of other things, including pool cleaning, that don't really apply here. Final point before we get to Burello is if you were an employee in a relationship as of January 1st of 2019, nothing in this new law permits reclassification of you to be an independent contractor. So there's definitely a bias towards maintaining the employee-type relationship. Now, Borello, we're not going to get into detail on Borello because, as you can see, it's a huge hullabaloo here. But a couple of points. So Borello was the test before Dynamex, a 1989 state Supreme Court case. Dynamex, as I said, has this ABC test. It's now in the law as AB5 that says if you have to satisfy A, B, and C, and if you do, then you definitively are an independent contractor. Otherwise, you're an employee. Borello was different. There were 14 factors.
About 5 if you want to do questions.
5 minutes?
Yeah.
Okay. We're just wrapping, in fact. Borello has 14 factors, but no one of them is definitive. It's not that you have to satisfy this one and this one and this one and this one, or this one or this one, or 2 out of, at least 3 out of 14 or whatever. It's loosey-goosey. And that has advantages and disadvantages. The advantage is that it's a more flexible sort of test. The disadvantage is that it's a test that's harder to predict the results in advance because you don't know what a court, in looking at a given fact situation, is going to do. I will, a lot of the issues in Borello are some of the issues that we had a few minutes ago. Control, whether the work is part of the company's business, who provides the tools, these kinds of things. I'll let you read that if you reach out to me for a copy.
Please thank Jonathan Handel.